Alright, today we're going to be discussing one of the more interesting areas of criminal law, that being defenses. So throughout the semester, we've spent a little bit of time discussing what makes conduct criminal. We've talked about certain things like actus reus, mens rea, causation, and the elements that prosecutors have to prove in order to obtain a conviction. But today we're asking a different question. What happens when a person clearly committed the act? What happens when there's no dispute that they pulled the trigger, they killed someone, or if they otherwise just violated the law? So the question is, can there still be circumstances when we decide to not hold them criminally responsible for their behavior? And to answer this question, we're going to be examining three famous cases: Regina v. Dudley and Stephens, State v. Norman, and Naghten's case. And each case forces us to think about the limits of punishment and whether the law should sometimes excuse or justify conduct that would otherwise be criminal. Alright, so I want to start off with a hypothetical. So imagine four people are stranded in the middle of the ocean. Let's just say their ship is sunk, they have no food, no water, and rescue appears to be unlikely for them. So the days start to pass, then weeks, and then one member of the group becomes seriously ill and appears to be close to death. The other members in the group believe that unless they act, that everyone will die. So they decide to kill the weakest member on board and use his body for food. So the question then becomes, should that be considered murder? Or should their survival excuse what happened? Now, there's no easy answer. Some people would immediately say yes, it's murder, and then some other people would probably say that hey, they would kill if they had to survive too. But the law eventually had to answer this exact question. So before discussing this case, let's briefly review criminal liability. So generally speaking, prosecutors have to prove several different elements. First is actus reus, which refers to the guilty act. Second is mens rea, which refers to of guilty mind or criminal intent. Third is causation. The prosecution has to show that the defendant's conduct actually caused the prohibited result. So normally, defendants challenge one of these elements, but sometimes defendants admit every element. So they admit they committed the act, they would say that they intended the act, but what they're saying is they shouldn't be held responsible because of the circumstances surrounding their conduct. And that brings us to criminal defenses. So we have justification versus an excuse, and this distinction is extremely important. A justification defense argues, what I did was legally acceptable under the circumstances. The act itself will become permissible. So examples of this would include things like self-defense, the defense of others, and necessity. An excuse defense is quite different. The defense is admitting the conduct was wrong, but argues that they should not be blamed. So examples include things like insanity, certain forms of duress, and you can think about it this way. A justified act is considered the right thing to do under the circumstances, but an excused act is still wrong, but we choose not to punish the actor because of some special condition that was affecting them at the time. So keep this distinction in mind because all three of these cases fall somewhere within these two categories. So let's begin with one of the most famous criminal law cases ever decided. Regina v. Dudley and Stephens was decided in England in 1884. The defendants were all sailors aboard a yacht called the Mignonette. The vessel sank during its voyage. The only four survivors aboard escaped into a small lifeboat. Those survivors were Thomas Dudley, Edwin Stephens, Edmund Brooks, and a 17-year-old cabin boy named Richard Parker. And what followed this became one of the most controversial stories in legal history. Now, some of the conditions at sea, as you can imagine, weren't favorable. The survivors had to drift for nearly 3 weeks, and at first they survived on nothing more than a few turnips that were salvaged from the vessel. And eventually the food ran out, water became scarce, and the men had to drink rainwater whenever possible. At times they even drank their own urine to stay alive. But the cabin boy, Richard Parker, became especially weak after drinking seawater. His condition rapidly deteriorated. He became extremely ill and eventually slipped into a near comatose-like state. And at this point, the survivors believed that rescue was unlikely, and they feared that all four of them would die. And this leads us to the killing. After approximately 20 days at sea, Dudley proposed a solution. He suggested sacrificing Richard Parker. His reasoning was straightforward. Parker was already dying, the others were healthier, and by killing Parker, they believed the other 3 lives could be saved. Stephens agreed. Brooks refused. He didn't actively participate, but he didn't stop them from killing Parker either. Dudley then killed Parker with a knife. The men then consumed Parker's body and drank his blood. 4 days later, they were rescued. The survivors returned to England, where they were charged with murder. So now we get into the legal question. The legal issue here was simple to state, but difficult to answer. Can necessity justify murder? More specifically, can a person intentionally kill an innocent individual in order to save multiple other lives? Notice that nobody disputed the facts. The defendants admitted exactly what happened in this case, and the question was whether the circumstances actually excused their actions. So when we get to the defendant's argument, they're arguing this is necessity. Their reasoning was that everyone would have died otherwise. Parker was already near death, 3 other lives were saved by killing him. And so from their perspective, the killing represented the lesser evil. In modern language, we might describe this as a cost-benefit calculation. Remember back to the utilitarianism that I taught you earlier. So you lose 1 life, but you're saving 3 other lives. The defendants argued that the necessity justified their actions. And now we get into the court's decision, and the court rejected their argument. The defendants were convicted. The judges held that necessity is not a defense to international murder, and this became one of the most foundational principles of criminal law. Even under the most extreme circumstances, intentionally killing an innocent person remains unlawful. Now, why did the court reject necessity? Now, the court worried about where such a rule might lead. If necessity justified murder, who gets to decide whose life is worth more? Could stronger people sacrifice the weaker people? Could society justify killing vulnerable individuals if doing so benefited others? And the judges feared that there would be no principled stopping point. So the law therefore refused to recognize necessity as a defense to the murder of Parker. And again, think about the precedent that the court would be creating here. If necessity became a defense to murder, then the court would have to decide when 1 life is worth sacrificing for another. Could a doctor kill 1 healthy patient to save 5 others who need organ transplants? Could a group stranded in the wilderness vote to sacrifice the weakest member? Judges feared that there would be no clear limiting principle here. Once the law allows innocent people to be intentionally killed for the benefit of others, it becomes difficult to determine where that rule would end. So the case of Dudley and Stephens remains important today because it establishes limits on necessity. The case forces us to confront difficult moral questions. Sometimes what seems morally understandable can still be legally prohibited. And this tension between morality and legality appears very commonplace throughout criminal law. And I think what's interesting is that many people disagree with the court's conclusion here. Some people would argue that the sailors acted reasonably under impossible circumstances, and others believe that the court was correct because the law should never authorize the intentional killing of an innocent person. So the tension really highlights an important lesson that I would just implore you to understand, that these legal answers and moral answers are not always the same thing. Now, this brings us to our second case, which involves self-defense. So unlike Dudley and Stephens, this case concerns domestic violence. State v. Norman was decided by the North Carolina Supreme Court in 1989. The defendant was Judy Norman. For years, Judy suffered severe physical, emotional, and psychological abuse at the hands of her husband. And the evidence in this case just shows a horrifying pattern of abuse. Her husband repeatedly beat her, he threatened to kill her, he humiliated her, he controlled her movements and activities, and many of the witnesses described years of violence and intimidation. And by the time the case reached court, there was little doubt that Judy Norman had endured just an extensive amount of abuse. And this leads us to the shooting. So one day when Judy Norman's husband fell asleep, while he was sleeping, she retrieved a firearm and shot him in the head. And the key fact here was that her husband was asleep at the time, and he wasn't actively attacking her at the moment she fired. So that single fact became central to the entire case moving forward. And this, of course, brings us to the legal issue, the legal question here being whether or not self-defense could apply. So traditionally, self-defense requires there to be an imminent threat. In other words, the danger must be immediate, and the court had to determine whether or not years of abuse could satisfy the requirement even when the abuser was still sleeping. So the concept of imminence is definitely one of the more important requirements in self-defense law. Traditionally, courts require that the threat be immediate. You can't just generally use deadly force against someone because you believe they might harm you next week, next month, or sometime in the future. And the challenge here in the case of Norman is determining whether or not the years of abuse create a different type of imminent danger that the courts can traditionally recognize. So the argument Norman used was that the danger never truly disappeared. She believed that her husband would eventually kill her. The abuse was ongoing. And so waiting until the next attack meant that she might not survive. And her attorneys argued that her actions were therefore reasonably still self-defense. And of course, this brings us to the court's decision. The North Carolina Supreme Court rejected the self-defense claim. The court focused on the concept of imminence. Because her husband was sleeping, there was no immediate danger. There was no immediate threat at the exact moment of the shooting. And without imminence, traditional self-defense couldn't apply. And so, as you can imagine, this case is very controversial. It continues to generate debate even today. So, many of the critics argue that the law failed to account for the realities of domestic violence. And many of the supporters argue that removing the imminence requirement could allow almost any future fear to justify homicide. And so, the case is really highlighting the difficulty of applying traditional legal norms to complex human situations. There's a whole lot of nuance in here, and there's no black and white. Okay, we've reached our last case. Finally, we turn to insanity. Now, Naghten's case is one of the more influential criminal law decisions that's ever been issued. Daniel Naghten suffered from severe delusions, to put it lightly, and he was believing that powerful political figures were conspiring against him. And so these beliefs, of course, they're not based in reality, but at the time, he genuinely believed them. Right. So Naghten decided to strike back against those he believed were persecuting him, and he attempted to assassinate the British Prime Minister. But instead, he mistakenly shot and killed the Prime Minister's secretary. And there was no dispute that Naghten committed the act, and the question was whether or not he could be held criminally responsible for his actions. So the defense argued that Naghten suffered from a serious mental disease, and because of his delusions, he could not have accurately perceived reality. So his mental illness fundamentally affected his overall understanding of the situation, and therefore Naghten's defense argued that criminal punishment wouldn't be appropriate. And this is where we get to the Naghten rule. The case produced what became known as the Naghten rule. Now, under this test, a defendant may be legally insane if, because of a mental disease or defect, they did not understand the nature and quality of their actions, or they didn't know that their actions were wrong. Now, notice how narrow this rule is, because mental illness alone simply isn't enough. Now, the illness has to prevent the defendant from understanding that what they were doing or from understanding that their action was wrong. And one common misconception here is that the insanity defense applies whenever someone just suffers from mental illness alone. And like I mentioned before, this is just not the case, as we have many individuals in society who are diagnosed with mental illnesses, and they're still held criminally responsible because they understand what they're doing and understand that their actions are wrong. But overall, the Naghten rule is focusing on a very narrow question. Did the defendant's mental condition prevent them from understanding reality or recognizing the wrongfulness of their actions? Now, the Naghten rule became a foundation of insanity law throughout much of the English-speaking world. So many American jurisdictions continue to use different versions of this test today, and the case remains central to discussions about criminal responsibility and mental illness. So despite the public attention surrounding this high-profile insanity case, insanity defenses are actually quite rare. Research consistently showcases that defendants raise insanity only in a small fraction of criminal cases, and successful insanity pleas are even less common, as you would imagine. So the public often assumes that insanity defense is widely abused, but the overall empirical evidence generally suggests otherwise, so I think that's just worthy of noting. Now, when we compare all of the cases here, you can notice some of the similarities, because in all three of these cases, the defendants, without a doubt, committed the act, and the disputes really centered on the responsibility. So Dudley and Stephens claimed necessity, Norman claimed self-defense, Naghten claimed insanity. So each case here is really asking when society should excuse or justify conduct that would otherwise be criminal. Now, I want to leave you with several different questions. Should necessity ever justify murder? Should Judy Norman have been acquitted? Does the law adequately protect victims of domestic violence? I would argue that in Judy Norman's case, I don't think so. Is the insanity defense too broad, too narrow, or would you say it's about right? And again, most importantly, what do you think should matter more? Moral blameworthiness or just strict legal rules? I think these are all very, moral and ethical quandaries that we should definitely ponder as we move forward throughout the semester. And once again, all of these questions have no universally accepted answers, and this is just precisely why these cases remain more important than a century after they've been decided. So with this, I conclude today's lecture, and if you have any questions, feel free to email me.